Are you struggling to get the wages you're owed? Discover the essential steps to file a wage claim with the Indiana Labor Board and protect your rights as a worker. Welcome to this comprehensive explainer. I'm your host, and today we're tackling a critical issue that affects so many hardworking folks out there. We're going to break down exactly how you can navigate the wage claim process right here in Indiana, relying on nothing but the hard facts.
Okay, let's dive right into this incredibly frustrating yet all too common situation. It's a harsh reality, actually. According to the Economic Policy Institute, workers lose billions of dollars every single year to wage violations. Billions. And why? Well, a lot of times it's simply because employers bank on the fact that their employees might not know their rights, or maybe they don't know the legal avenues available to them. But today, we're going to explore exactly how you can fight back and reclaim what is rightfully yours. To do this efficiently, here's our game plan. We'll start with an intro to wage claims, move through eligibility, the filing process, timelines, outcomes, and finally wrap it all up with some great resources. Let's get right to it.
Section 1. Intro to Wage Claims and Understanding Your Rights.
First things first, let's get our definitions straight. What exactly is a wage claim? Well, it's a formal process initiated through the Indiana Department of Labor, the IODO, to recover earned, unpaid compensation. We're talking about regular hourly wages or overtime. Now, the absolutely crucial point to remember here is that a wage claim is an administrative tool. It's super useful, no doubt, but it's not some magic wand that just forces an employer to pay up without a process. Filing a claim initiates an official investigation. The IODL doesn't have the power to just, freeze your boss's bank account and hand you a stack of cash on the spot. It is the very first step in a highly structured legal process.
Now, here is a really bizarre twist in Indiana law. Your current employment status actually dictates entirely different legal hurdles. If you're a current employee, meaning you're still clocking in for the employer who shorted you, you can actually bypass the state agency entirely under the wage payment statute and file a lawsuit right away without jumping through those administrative hoops. But if you are a former employee, you fall under the wage claims statute. This means you absolutely must file a formal claim with the Indiana Department of Labor before you're legally allowed to file a lawsuit against your old boss. It's a strict jurisdictional prerequisite. If you try to skip this step and go straight to court as a former employee, your case can and likely will just be dismissed. Section 2, Eligibility and Documentation. Let's get you ready to file.
So, how do you know if you even have a claim? Well, if you've been shorted in ways like unpaid overtime, which, remember, federal law dictates should be 1.5 times your regular rate, or maybe you faced minimum wage violations, dipping below that $7.25 an hour mark, you probably have a solid claim. This also covers things like off-the-clock work, illegal deductions for uniforms or cash register mistakes, and delayed final paychecks. But get this. Here is a surprising fact that catches a lot of Indiana workers off guard. State and federal law actually do not legally mandate meal or rest breaks. Crazy, right? So while unpaid time you actually worked is definitely covered, just the mere lack of a lunch break isn't actionable under Indiana state law. Now, if your situation does fit the criteria, it is time to gather your evidence. Before you go rushing to the government, remember that a paper trail is your absolute best friend. First, and I cannot stress this enough, make a written internal demand to your HR department or your manager. Trying to resolve things internally first provides powerful evidence if they decide to just ignore you. Second, gather all your pay stubs and employment contracts. Third, round up your personal timesheets and any relevant communications. Seriously, even simple calendar entries or text messages to your coworkers about swapping shifts can be incredibly valuable when you're trying to prove you worked hours that you weren't paid for. All right, moving into Section 3, the filing process. Step by step with the IDOL. So, the Indiana Department of Labor has very strict jurisdiction when it comes to the dollar amount. They can only process administrative wage claims that fall between $30,000 and $6,000. If you're claiming $20 or if you're claiming $10,000, the system is literally going to block you. If your claim exceeds that $6,000 cap, you'll have to seek private legal counsel and submit a physical claim to obtain a mandatory letter of referral so you can take the issue directly to court. But if your claim does fit nicely into that window, here's your path forward. First, you have to pass 6 online screening questions. These just verify things like your status as a standard employee rather than an independent contractor. Because, just a heads up, independent contractors aren't covered by these specific wage laws. Next, you need to complete the form entirely. Don't skip anything because incomplete forms will just be rejected. Finally, and this is absolutely vital, you have a strict 2-week window from the date you submit your claim to provide all your supporting evidence via email, fax, or mail. If you miss that 2-week deadline, your claim grinds to a complete halt. Section 4, timelines and expectations. The clock is definitely ticking. You really need to act fast. An employer generally has 10 business days to issue a final paycheck after a formal demand from a departing employee. Beyond that, you have exactly 2 years for standard state wage claims. You get 3 years for federal Fair Labor Standards Act violations, but that's only if the violation was willful, meaning your employer knowingly or recklessly broke the law. And you have up to 6 years for a breach of a written employment contract. So while you might have years to hash out a written contract dispute, that standard window for unpaid wages closes in just 2 years. Seriously, do not wait on this. Once you've successfully filed and submitted your rock-solid evidence, you're going to need to practice a little patience. The idle process typically takes up to 90 days, and that timeline heavily depends on your employer's cooperation, as well as just the sheer volume of claims the department is dealing with at the time. Section 5, Outcomes and Appeals. What happens next? Ultimately, the outcome really hinges on the employer. If they agree to the claim, fantastic. They have to pay up within 2 weeks. If they dispute it, the IDO reviews the evidence and makes a determination based on Indiana law. But what if the employer just ignores the state entirely? Or what if your claim was over that $6,000 limit we talked about? In those cases, the IDL issues a letter of referral. Like I mentioned earlier, the IDL can't independently force a stubborn employer to cut a check. But this letter of referral, it's basically your golden ticket, giving you the green light to retain private legal counsel and take the fight straight to civil court. Now, by elevating a denied or ignored claim to a lawsuit, you actually unlock some new potential compensation. Indiana law allows for liquidated damages of 10% per day, all the way up to double the total paycheck amount, plus your attorney fees. Think about that. It is a massive financial penalty for employers who willfully withhold wages, and it's something the IDOL administrative process simply cannot grant you on its own. However, we need to highlight a massive exception here. Just a quick warning for any state employees tuning in, people who actually work for the state of Indiana. Case law, specifically a landmark decision called Abner v. Department of Health, dictates some unique rules for you. In that specific case, residential state workers sued over unpaid sleep time. The court ruled that overtime pay is technically considered a condition of employment. Because of that, you absolutely must exhaust the State Personnel Administration Act grievance process before a court will even glance at your wage claim. You can't just skip ahead to the wage payment statute or wage claim statute. You have to play by the specific administrative exhaustion rules for state workers first. Finally, Section 6, Resources and Disclaimer, How to Protect Yourself. You actually have multiple agencies in your corner, depending on the nature of your claim. You can contact the Indiana Department of Labor for state wage claims and final checks. You can engage the U.S. Department of Labor's Wage and Hour Division if your employer violated federal minimum wage or overtime laws under the FLSA. Now, if there's a discrimination element tied to your withheld pay, the Indiana Civil Rights Commission is there to help. For unemployment issues connected to your departure, the Department of Workforce Development is your go-to. And of course, local employment attorneys are totally invaluable for navigating the complexities of the court systems. Now, a really common fear people have is being fired for speaking up. And look, because Indiana is an at-will employment state, state law technically offers no job protection purely for filing a wage claim. I know that might make you nervous. However, federal law strictly prohibits retaliation. If your employer fires you, demotes you, or suddenly cuts your hours in response to a good faith wage complaint under the FLSA, they have blatantly broken federal law. In that scenario, you likely have a separate, very strong retaliation claim against them. As we wrap things up today, please keep our evergreen disclaimer in mind. The legal landscape is always shifting. Deadlines can be modified, and administrative procedures get updated from time to time. Please treat this explainer as your starting block, an educational foundation. You should always consult a legal professional or directly contact the Indiana Department of Labor to get the absolute most up-to-date information before you proceed with your specific, unique situation. Look, you put in the hours. You did the hard work. You upheld your end of the bargain. So the only question left is, are you ready to take the first step to claim what you've rightfully earned? Thank you so much for checking out this explainer. Remember, never settle for less than what you are owed, and we will see you next time.